Hey everyone, Harry here to talk about the hearing that Judge Scott McAfee held in the Fulton County RICO case on Friday and what it portends. We haven't had a hearing from him in a while, and he's a judge, as I've said before, he's impressive, and he gives a sense to the parties of where he's trending so they can try to talk him out of it. And all this matters a great deal because the timing of the Fulton County trial is really a very important factor that's been a moving target. So, Fani Willis first was like, let's do it next week with all 19 of them. She was ready to go in October. And then she staked out, a little oddly to me, a trial date in August, and she's, by her own estimate, that trial could not finish before the November 2024 election. But that was the request she's now put in. It hasn't been granted yet. There are important things up in the air. There's a motion before the court to have 3 trials, as best as I can read it, to split the remaining defendants in 2 and then cleave off Trump and as a whole separate person. Nobody wants to be sitting at a table with him. Anyway, there's different kinds of pretrial motions pending, and on Friday he heard 3 of them, and he did not decide any of them, but it was nevertheless an informative hearing, especially on this issue of when are we going to go to trial in Fulton County. Okay, he had the whole array in front of him. He had Trump first basically saying, put this off forever. It's very interesting whether Trump, obviously what he wants to say, what he believes, or what he thinks is his whole card is the election is coming. So first there's the whole election battle, and then the possibility he's president. And that means basically you should put this off forever. I'll sort of come back to it, but he's express about the election stuff. In D.C., he's not, because Judge Chutkan has made it clear, I don't care about the election. I'm not going to have affect my calendar at all as a result of it. So he tiptoes around and gives reasons without mentioning the election that everybody understands are really just camouflaged efforts to try to push back past the election. And then in Mar-a-Lago, Aileen Cannon seems to be fine to let him be talking about the election. So there he raises it. All right. In front of McAfee, his lawyer dominated the proceedings, it was a multi-hour hearing, and Trump's lawyer was always at counsel table, whatever was being argued, always sort of putting his 2 cents in. And he had a sort of 2-part argument that I think is properly referred to as heads I win, tails you lose. Toward the DA, it was, if you have this trial in August, when she's asked for it, through November, it's the most patent form, he said in very dramatic terms, of election interference conceivable, or something like that. And, obviously there is a certain ungainliness to having an election, presumably between Trump and Biden, coming down to the finish line while one of the 2 candidates is in criminal court every day. Of course, in some ways, I think we're well aware that that's Trump's preferred spot, because it's where he gets to sound all his themes and then come out and rail against the deep state and tell his, really rally his base, because the liberal elite powers that be, or whoever they are after him. And that means they're after the base too, et cetera, et cetera, et cetera. But anyway, he says, look, you can't do it before because that's election interference, and you can't do it after because, at least not if Trump wins, because the supremacy clause is how it was put. And what he means by that is, if he's the president, the Supreme Court will find a principle in the Constitution that says you can't imprison a an actual sitting president. So as to that, it all sounds of a piece, but here's the important one of the important legal punchlines. As to a post-election, he's right. If Trump wins the election and there are still pending cases, or even he's been ordered into jail, the Supreme Court should find that the supremacy clause does force the state to give ground there, and you can't, knock on the door of the White House and haul away the sitting president of the United States. That just even if there's a completely valid, impeccable trial, that you have to put it on hold, put the consequence on hold until after he's finished his tenure. So on January 20th, what are we talking about? 2029, the Georgia marshal could, knock on his door and put handcuffs on and try to take him away. Of course, by then, if Trump's actually been president for 4 years, is Fani Willis in jail because he's we're in a constitutional republic, or if we are, that does not look like the one we've known for 200 years. I mean, it's, Trump would calculate that he'll figure out a way out of it. Well, he's president, and he might well, given his ruthlessness and promise essentially to shred the Constitution. Okay, so that does leave, however, it's not a heads you win, tails you lose, because there's, as Judge Chutkan has said, there's no constitutional principle of election interference or that you can't do this. So I think McAfee should find that he can be put on trial. Maybe it's the middle of the convention. Maybe it's maybe it's the stretch run of the campaign. There's no bar to his actually being put on trial. So that, I think would be in McAfee's mind. Indeed, McAfee made one comment that really made my ears perk up. He said, what if one of the federal courts change its schedule so that an opening is created earlier than August? And he's obviously thinking of Aileen Cannon, who did this huge delay that will necessitate her pushing the trial back several months, into like August, but did it in a kind of, cunning way, because she said, she won't address the actual movement of the trial until this next round of motions, which I think serves to insulate her from a motion by the United States to try to recuse her. Anyway, McAfee is on top of this. And so, and I think he's on top of the whole timing issue. So he may counter what again is a perplexing move in my mind by Fani Willis not to have the trial till August. So if there's a delay in Mar-a-Lago, maybe they slip in and say, let's start this one now in July. And the question that McAfee posed to the prosecutors, which didn't have much to do with anything, so that's why I, really paid attention, was how long would it take you, state, to get ready if we found all of a sudden there was an opening? And the state said 30 days. So, the idea may well be that he'll be looking to do it earlier as soon as Cannon pushes her trial back, which she is going to do it, and she's as much as done without doing the final stroke of it. Okay, so that's the Trump piece and the McAfee piece. Now, in addition, he's got Clark and Eastman. Eastman, I think, is just dead broke, and he's saying he doesn't want to wait that long for the final plea date. I don't know what he thinks is going to happen. I guess he still is hoping for some kind of favorable plea deal of the sorts that the other lawyers got, non-custodial jail time or the best he could do. And he wants that to happen sooner than later. So he's saying move things up, set the trial, but most importantly, the final date to enter guilty pleas, make that be sooner. And then conversely, you have Clark saying, I'm in disciplinary proceedings in DC. They're trying to take away my license. I want those to play out first. So delay things. He's on the Trump delay plan. So McAfee has, all over the map, proposals for when to do the trial, including a fairly late one by Fani Willis. He also has sort of all over the map. He's going to be hearing, in fact, in a few days, Mark Meadows' motion to say, put mine off anyway, until my removal motion, which I lost in the district court. Remember, those ones go to federal court. Put that off until the Court of Appeals, which has it now, decides. So in addition to the when to make the first trial, McAfee, it's ripe for him to make a decision about how many trials. Should there be one only, which is what the state wants? And I think once my expectation is most of the defendants, about the half or so that are left, are Georgia elector types who played a pretty small part, and they will likely plead out. And what the DA will want is for them to testify against the bad actor here, David Schaefer, who was the head of the Georgia party. So if that happens and we begin to look, I don't see it winnowing much below 6, maybe, but easily could go to there. So the question then will be, will he hold, let's have a single trial. I'll deny the effort by Clark in particular to be separated from Trump. So the issues in front of him, when's the first trial going to be and how many trials? And he's thinking about it with, in a nuanced and sophisticated way. He understands the delay stakes, for the country. And we'll await his decision. But Trump's basic heads I win, tails you lose argument really ought to fail, because if anything, it should be pushing McAfee to do it sooner, because if he does win, tails, the state of Georgia does lose for 4 years. So there you have it. Always interesting when McAfee is in court. He's sharp, he's prepared, and he shows what he's thinking about. And now we'll await his actual decisions on Trump. Let's just put it all off. On Clark, let's wait until my proceedings are done. And Eastman, let's move it up sooner so we can come to the plea bargaining stage more quickly. And then Meadows soon to follow. So a lot of action in McAfee's court. And once he rules, the shape of the number of trials and, more importantly, the scheduling of the trial ought to be a lot clearer. Not completely, because there's other things he's still juggling, but a lot clearer. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.